Alright guys, what's up? It's your boy Legal Doc Guy. We're going to run through the 2012, July 2012 question 3. It's a criminal law question. No, this is an evidence. It's a fun story. We're going to just run right through it because it's a Saturday and I got a lot of stuff to do. We got 81 days until the California bar exam, day one of the California bar exam. So I don't know if you guys are ready. I know the answer. You're not. So what we're going to do is we're going to go through this essay. Just give you guys a few good rules that you could use. This is actually a really cool one. So this is really good stuff because there will be instances, and I'm assuming you guys have read it already, but we're going to read through it real quick once together. But this could be a real life situation when you're practicing law and you have a situation where you're in a murder trial and you have witnesses that either the defense or the prosecution want to call to admit evidence against the defendant, and you got to figure out whether or not, if you're a good defense attorney, whether or not you can keep this evidence out or not, because your client's life is on the line. Okay, so let's go ahead and put up on the screen the 2012, July 2012 question. Oh, this is a question 2 I have up on the screen. That's not what we're going to be looking at here. Oh, that's... You know what? I'll just go onto the State Bar's website. So if you haven't done that before, you just go State Bar California, right? You scroll down to where it says California State Bar. Right here, California State Bar. Then you go here to admissions. This is admissions. Click on that. They always have this weird looking girl right here. Just kidding, she's not weird looking. But they all have that dork right there. I'm just kidding, she's not a dork. But you know what I'm saying. They have that girl right there. It's been the same girl for like 20 years. They haven't updated this at all. So the cool thing about the California bar examiners is they don't change much, and when they do change something, they screw it up. Okay, so we have past bar exam questions and answers right here. Okay, if you need to know deadlines and dates, you can go right here. Click on that. See passage rate statistics, admission fees, all that stuff. First year law student examination, everything is here. Multi-state professional responsibility examination, PRE. You can get information on that and blah, blah, blah. But for our purposes, we're just going to go California bar examination questions. These are only the questions. If you go down to the second set, it's the same questions, but with the 2 answers that they decided on the bar exam that they wanted to publish. Now, I'm not exactly sure how people get published on the bar exams. You know, I mean, you got thousands of essays. So these aren't necessarily they are the best. They are what they consider the best questions, or the ones that they feel are going to be most helpful to the students, to people who are taking the bar exam. As an example, you'll notice a lot of times some are very sophisticated, some are not all that sophisticated. High level passing students. I mean, these are probably guys from women, guys. You know what I mean. They're probably people who went to top notch schools like Harvard, Yale. Some of these Ivy League schools, probably not anymore because those colleges are obviously lost their minds and they're just admitting Stanford, probably not even those guys, right? Who knows? Maybe Columbia Law. I don't know, but they're really smart people and they put together some pretty good answers. So anyway, enough about that. So what I'm going to do here, because I don't really care about the answers. What I care about is just the question. I don't want to have to scan through a bunch of answers to get to the question. So I'll just click on July 2012, and it's going to pop up the questions from 2012. That's question 2. But what I want is question 3. Is this question 3? No, this is question 2. And then here's question 3. Boom. Okay, now I'm going to shrink it a little bit, because otherwise... think it's a good idea to pull this up on your own screen, so that way you can see it. Oh wow, look at this. It's a long question, you guys. All right, but I want to get the whole thing up on the screen so I can just read it without scanning through it. Let me see here. Here we go. Oh. Okay. On your computer, if you're not able to watch me and your screen, like me, I have multiple screens and stuff like that, so I could see what's going on here, I could see what's going on with the video, all that stuff. I have my software up. Okay, so I'm just gonna read it to you, and then I'll try to save my commentary, but I just love getting some commentary. All right, so Vicky was killed on a rainy night. Okay. The prosecution charged Dean, a business rival, with her murder. It alleged that on the night in question, he hid in the bushes outside her home. Holy smokes. So, right off the bat, this is a cold-blooded guy. If he actually in fact did. What he's being accused of is pretty, I mean, that's first degree murder right there. Is that important for this fact? I don't know. You know, we don't really know. And you know what? That kind of jogs my memory here. To just start off reading the first paragraph like I just did, you're going to be like, oh, this is a murder question. But is it a murder question? Well, what we should have done, what I should have done, and I'm glad that I went through this like this, is that we should have started with the call of the question. Then we would know if this is a question about murder or not. Right? This is a murder question. I need to talk about first degree murder and second degree murder, and I need to talk about mitigation, or what do they call that? Manslaughter and all this other stuff, right? And lying in wait. He's lying in wait, talking about all this nonsense. Your brain just kind of thinks you're in this area. Go and start over, okay? So what we should have done is just read the call of the question. You'll see right here. Maybe I shouldn't put my arrow too big because now it does that. I don't like that. But anyway, if you start here, assuming all appropriate objections and motions are timely made, did the court Whitney? And 2, admit the testimony of Whitney, Ella, and Fred. Okay, you can't see it because this stupid bar came up, but Fred. Question about witnesses in a criminal trial. Okay? There's Whitney. I don't know who Whitney is. I don't know who Whitney is yet. But I do know that the question is asking me, was it proper for the prosecution to call Whitney as a witness? And then 2, was it proper to admit the testimony of Whitney, Ella, and Fred? Okay? So that's the first thing I should have did. I should have went through the right directly to the call of the question, because that's going to let you know what area in the law you're in. First of all, you're going to realize, oh, I'm in criminal law. This is an evidence question. Right away, you'll know this is about evidence. So then your brain goes into the evidence realm of the law. Okay, but then evidence about witnesses, witness testimony. Okay. So we don't know exactly what about, what type of evidence, but we do know it's going to be something having to do, it could have something to do with, relevancy questions. We don't really know, but we need to know, was the evidence proper? Okay? The first question, and question 1 and question 2. Question 1 is simply asking us, was it proper to call Whitney? Because you notice her name comes up again in question 2, the testimony of Whitney. Okay. The first question is just whether or not the prosecution had the right, or was it proper for them to call her to the stand? About the facts, right away though, we know that Vicky was killed in a rainy night. So and the prosecution charged Dean. Those 2 right there let us know that we're in a criminal trial, or that we're in the this is a criminal prosecution of Dean for the murder of Vicky, who's Vicky because she's the victim, okay? Who was a business rival with her murder. He hid in the bushes outside her home and shot her when she returned from work. Pretty cold-blooded, if you ask me. At Dean's trial in a California court, the prosecution called Whitney, Dean's wife, to testify. Okay, so Whitney is Dean's wife. 1 week after the murder, Whitney had found out that Dean had been dating another woman. Oh man, Dean was not being a good guy. Right? This guy probably, he might be like a high-level guy. He's a business rival, so he's probably a high-level dude. And he just like got all into himself. He was feeling himself, and he started dating some other chick. And now look at now his wife decided that the marriage is over. So not only did he kill somebody, so allegedly, but now he's an all-around bad guy. All right, but let's read on. Still angry, Whitney was willing to testify against Dean. Dang, she's willing to not. She's gonna burn her husband down. Ooh, that's what you get. All right, but anyway, after Whitney was called to the stand, the court took a recess. So she was called to the stand, and then she took a recess. Okay. He must be a looker. He must be a really good-looking guy, high-level guy, probably makes a lot of money. And she was like, you know what? I'm just gonna stay back and sit. Okay. And then Whitney decided not to testify against him. Okay, that's fine. Then the trial commenced, and the prosecutor asked Whitney if she saw anything on Dean's shoes the night of the murder. Were you guys able to hear that phone call? You guys probably were able to hear that phone call. Okay. That was my wife calling. I'm not sure what she wants, but I should have told her I was. Okay. Recording. I would let her talk, but you never know what you're gonna get. Okay, so during recess, Dean and Whitney reconciled, so they made up. Now Whitney anything on Dean's shoes the night of the murder. So now she's probably up there on the stand like, I'm not going to answer these questions. I'm not answering. We reconciled. And then when Whitney refused to answer, the court threatened her to hold her in contempt. Right? They said, bitch, if you don't answer, you're going to jail. That's basically what they told her. Reluctantly, so she didn't want to because she loves her man. She testified that she saw mud on Dean's shoes. Now, it's raining. I mean, that mud could have came from anywhere. What kind of evidence is that? But anyway, so the prosecution, so the next facts tell us. So that's all we know about that part, right? That's Whitney. You'll notice that everything about Whitney is in this paragraph right here, okay? But then we get into Ella. The prosecution then called Ella, Dean's next door neighbor. Ella testified on the night Vicky was killed. She was standing 20 feet from an open window in Dean's kitchen. Man, this bitch better hope that Dean doesn't go to prison because they live right next door to each other. And if he, if this guy gets acquitted, would you want that murdering son of a bitch hanging out, watching you through your kitchen window, like probably thinking about how am I gonna kill you? I would have just left it alone. But anyway, she also testified that she saw Dean and Whitney, and she heard Dean tell Whitney, I just killed a gal. I just killed the gal who just stole my biggest account. Wow, really? You killed the bitch just because she, over an account? That's silly. I mean, don't mess with somebody's money, you know what I mean? Anyway, so Dean and Whitney did not know that Ella overheard their conversation. So they didn't even know that she could hear from 20 feet away from her house from her kitchen window. Now, I don't know about you guys, but I couldn't hear. Their kitchen's probably about 30 feet from our kitchen window because there's like a driveway separating us and all that kind of stuff. Like, I've never once heard them talking in their kitchen, ever. They are. Okay, so if it says that she heard them, then she heard them, okay? All right, the paragraph here is about Fred. Okay, so then Dean calls Fred a friend to testify. How convenient, it's his friend, right? Fred testified that on the day coffee shop when he saw Hit, a well-known gangster, conversing at the next table with another gangster, Gus. Wow, okay. If he had taken care of the assignment concerning Vicky. Well, what does that mean? The assignment. And then that Hit then drew his index finger across his own throat. Okay, wow. How fortuitous is that? Fred, I think Fred's a liar, but we'll find out. So assuming all appropriate objections and motions were timely made, did the court properly allow the testimony of Whitney, Ella, or Fred? Answer according to California law. Okay? So we're going to use California law. We're not using ABA. I mean, ABA probably wouldn't even matter anyway because this is a state. This is, in criminal matters such as this is a state. It's a state that's prosecuting the defendant, not the federal government. So stating answer according to California law, probably not really necessary to have you have that there, because if you're taking a bar exam in California, criminal law, or New York criminal law, you're in California. So no kidding we're going to answer according to California law, because that's what we study. Actually, I don't know. You're right. You know what? Some people study at law schools in New York and they come to California. But you better know California law if you're going to take the California bar exam, right? Because they don't play no game here. All right, so what's the first issue? The first issue is whether or not the court properly allowed the prosecution to call Whitney, okay? Whitney is the wife. So we'll put a heading, whether the court properly allowed the prosecution to call Whitney. And our first issue that I can see from here is going to be the spousal testimonial privilege. So that's a California Evidence Code section 970 et sec. So that has to do with so under California spousal testimonial privilege, STP, a married person may not be compelled to testify against their own spouse in a criminal proceeding. So you guys out there, this is important to know, because if you're going to get married someday and you're going to have to kill somebody, you want to make sure the only person you're going to tell is if you got to tell anybody, which I wouldn't advise you do, but if you told somebody, probably want to be your wife, know what the rules are on that, okay? So let's go down and just talk about the main rules, okay? What I should do is one day have it set up so that it has the bullet points of what these are, so you're not just listening to me say it. So what you would have to do is pause the video, write it down, and then rewind the video, or go back a few seconds and just write it down until you know it, which is probably not a bad idea, okay? As I told you before, I like to make these little booklets. So I make these little booklets, okay? Right here. I make these little booklets, and I'll write the rule. So what I did is I wrote testimonial privilege, or witness testimony, spousal testimonial privilege. I put the rule there, and then I wrote the heading, and then I wrote the right. And then what I'll do on any given day when I have nothing to do, I'll just copy it on the next page. I'll copy it, and then again, and then again. So I take two pieces of paper, I fold it in half, I lick it, and I bend it back and forth, and then I cut it in half so it's nice and perfect like this, and then I staple it together, and now I have myself my own little scratch piece of paper that I could use to try to remember. So anyway, so let's go through my list here. So the first prong is that the witness spouse holds the privilege, not the defendant's spouse. So his wife, you see in the fact pattern, Dean's wife, 1 week before the murder, when she found out that he was dating some other bitch. He was banging someone else. And so she's like, I'm going to testify against this guy. Like, screw my husband. So guys, if you're out there and you got a wife, make sure that if you're going to kill somebody, that you're being good to your wife, okay? Because she could be your alibi, or she could be that piece of evidence the prosecution needs to send your ass to prison. So, take it for what it is. So anyway, so he's cheating on her. She's still angry. Whitney is willing to testify. So she's willing. That first prong there, the witness spouse holds the privilege, she's mad. She could testify against him. There's nothing that she can get on the stand and testify if she wants to, okay? So after Whitney was called to the stand, the court took a recess. Okay? So where does this come in? Well, first of all, the second prong is the privilege applies only if the parties are married at the time of the testimony. Okay, so in order for this privilege, in order for the wife to not testify against her husband, they have to be still married, right? So if he said this to her, and we're going to get into this later, but if they weren't married at the time the prosecution wants to put her on the stand, there is no privilege anymore. Okay, it's only if they're still married at the time that they want to call her to the stand. It's not whether they were married at the time when he made this confession to her. It's about whether or not they're married at the time that she is going to take the stand. And at the moment, they're still married, technically. Because she said what did she say? She's dating another one, she moved out, saying the marriage is over. She's saying the marriage is over. But still, technically, there's no facts to suggest that there's been an actual dissolution of the marriage. Okay? Just because she states the marriage is over doesn't mean it's actually over. Okay? So that's important to understand that. Now, so they're still married. She's the one who holds the privilege. And then the third prong, the privilege may be waived voluntarily by the witness spouse. So she can waive she can waive voluntarily. The privilege may be waived voluntarily by the witness spouse. So she's already waived her. It says here, Whitney, the trial commenced and the prosecution asked Whitney. I'm sorry. During before that, right here. Okay. After Whitney was called to the stand, so she's called to the stand. She waived her privilege not to testify against her husband. Okay. That one sentence right there tells us that she waived the right because she was willing to testify. She's still married, but she waived it. Okay. So it's important to understand she's still married, but by getting on the stand to testify against him, she has now waived that right. Now, whether or not that waiver is reconcilable or revocable, revocable is probably the right word. Whether or not she can revoke that waiver, we will discuss in a bit. Okay? And it says, next prong, once waived, the witness may testify, subject to relevance and hearsay rules. So even though she could get on the stand and testify, her testimony is still subject to hearsay and the relevance rules, right? She can't just testify. She's going to testify about mud on his shoes, and that's relevant only to whether or not he was hiding in bushes, right? It says here he was hiding in the bushes, but I mean, you could get mud from anywhere, so I don't know what that's about. But anyway, so it's still subject to relevance and hearsay rules, okay? The last prong here says, the privilege does not bar the spouse from being called to the stand. Rather, it protects the spouse from being compelled to answer. Okay? So the privilege, what this is saying is that she still has to get on the stand. She could decide she doesn't want to testify, but she still has to get on the stand. So the privilege does not bar the spouse from being called to the stand. So she can't say, I'm invoking my privilege not to testify against my husband. The judge is going to be like, bitch, I don't care. You better get on that stand. You better get up there. Because if you don't, I'm gonna hold you in contempt. So she has to get up there, okay? But the privilege does allow her to sit there and be defiant and not answer the questions, so long as she's still married, okay? And she hasn't irrevocably waived the privilege. So the question is, does she still have the power to revoke the privilege? Because it says here, after Whitney called to the stand, the court took a recess. So at this point, she hasn't testified about anything. Okay, all she did was she took the stand. Okay, after Whitney was called to the stand, okay, the court took a recess. So basically, they said, "Wife, please take the stand." She took the stand. Maybe she took the oath. We don't know, but she hasn't answered any questions by the prosecution. I think that defense knew that she was thirsty for her husband, decided to ask for a recess, and then the judge granted the recess. He talks to his wife out in the hall. He's like, baby, I still love you, girl. Like, dude, I would never hurt you. Like, I didn't mean that bitch meant nothing to me. And she took the bait, and now she's willing to, she loves her husband, so she takes him back, and then guess what? Now she's not going to testify against him. But the question is, can she do that? Has she irrevocably waived her ability to now invoke her privilege again? Okay? So we're going to go through those rules, okay? So let's do this. Now we're gonna apply the facts and the law, okay? So we know that Whitney and Dean are still married at the time of trial. We know that, okay? And initially, Whitney was willing to testify because she's angry at Dean. So once she voluntarily agreed to testify, she waived the privilege, okay? And then during the recess, however, Whitney and Dean reconciled. So she changed her mind. She then sought to reassert the privilege, okay? Now the question is, can she do that? So under California, the laws of a spouse to allows the spouse to invoke the privilege at the time of testimony, even if previously willing, unless the spouse has already begun answering questions, thereby waiving the privilege as to that proceeding. So if she would have taken the stand, and if the prosecution would have asked her a question and she answered that question, she has now irrevocably waived her privilege not to testify against her husband. Okay? So here, although she had been called, she had not yet testified before that recess. Okay? The privilege had not been irrevocably waived. However, the prosecution was still permitted to call her to the stand because being called does not violate the privilege. She may assert, she may then assert and waive it. So once the prosecution got her on the stand, at that moment, the moment of truth, whether or not she was going to testify against her husband Dean, the moment of truth is when the prosecution put her back up on the stand and asked her, "Hey, what did you see on his shoes?" Or because the prosecution up here asked her at trial commenced, the prosecutor asked Whitney if she saw anything on Dean's shoes the night of the murder. So he asked that question, and she didn't want to answer. She invoked her right, her privilege not to testify. Okay, because it says here when Whitney refused to answer, the court threatened her to hold her in contempt. Reluctantly, Whitney testified that she saw mud on Dean's shoes. Okay, so the conclusion then is that the court properly allowed the prosecution to call Whitney to the stand because the spousal testimonial privilege does not prevent the spouse from being called, only from being compelled to testify. So that's our conclusion. So the first question it asks us, assuming that all appropriate objections and motions were timely made, did the court properly allow the prosecution to call Whitney? So the question is only asking us if the court properly allowed the prosecution to put Whitney on that stand. Okay? They're not asking yet in question 2 whether Whitney's testimony is admissible. They're just asking whether or not the prosecution, if it was proper for the court to allow the prosecution to call Whitney to the stand just to get her up there. Okay? And we know the answer is yes. Yes. It was proper for the court to allow her to get on the stand, and so there's no problem there. So our conclusion is that yes, the court properly allowed the prosecution to call Whitney to the stand, and that's simply because the spousal testimonial privilege doesn't prevent a spouse from being called. It only from being compelled to testify. So far, so good for the prosecution. They were proper in letting her get up onto the stand. Okay, so that's the end of our analysis and the rule for question 1. Now we're going to go into question 2. Okay, and it's got the same rule. Question 2 is still about the spousal testimonial privilege. Okay, and we would put a new heading. It would be the number 2, right? And it would have an A because we're talking about Whitney. See, you'll see here there's A, B, and C. So we're going to put 2A. So that way the readers know in the bar exam you're talking about the first witness. Okay, who we're still talking about Whitney. Okay, so then we put a heading, a subheading A, like I told you, and it's still talking about the spousal testimonial privilege because Whitney is the wife. Okay, so we're still talking about the spousal testimonial privilege. I already went through the 5 prongs of whether or not her testimony is admissible. So let's get to it. So just as we talked about before, Whitney attempted to refuse to testify after reconciling, and because she was married to Dean at the time and had not yet answered any questions, her privilege was still intact. She attempted to invoke it when refusing to answer the prosecutor's question. The court, however, they threatened her with contempt and compelled her testimony. So they forced her to answer the question. So now we have to establish that there's a rule. Okay. So the rule is if the privilege applies and the spouse invokes it, the court may not compel testimony. Forcing testimony violates Evidence Code 970. Okay, 970. What is 970? That's the spousal testimonial privilege. So if we apply this, Whitney's testimony was compelled under threat of contempt because she properly invoked the privilege. The court should not have compelled her to testify. Okay, so the conclusion here is that the court improperly admitted Whitney's testimony because her testimony was protected by the spousal testimonial privilege and she invoked it before answering. So, to recap again, the facts tell us that she got on the stand, but then the court took a recess right here. And during that recess, Dean and Whitney reconciled. And then Whitney decided not to testify against Dean. That was her right. She had not yet testified. The trial court recommenced, and the prosecutor asked Whitney if she saw anything on Dean's shoes. She invoked that right when Whitney refused not to answer. When Whitney refused to answer, she had effectively invoked her right not to testify. But it was only because the court threatened her. Son of a bitches. Reluctantly, she refused not to testify, and she only did so reluctantly. That means she didn't want to. Okay? So, then boom, we're done with the first witness. She's done. There's no need, we just hit it and get out. Okay? And then we go into the next witness, which is 2B, whether Ella's testimony was properly admitted. So here, Ella testified that she overheard Dean saying, "I just killed the gal who stole my biggest account." Right here. I just stole the gal where is it? I just killed the gal who stole my biggest account. Right? So that's what she testified to. And this statement raises, issues of hearsay, admissions, privacy, and marital communications privilege. Okay? The one that I think is the biggest is the marital communications privilege. Okay? But we still have to deal with hearsay. So this is an evidence question. So we want to make sure that we deal with hearsay, and we don't really need to go into a whole hearsay analysis and a prejudicial analysis. So we don't have to necessarily put headings that say, logical relevance and legal relevance. We could probably, for this particular issue, because the real meat of this is going to be in the marital communications privilege, which is different from the spousal testimonial privilege. Okay, and I'm going to explain the difference in a second. But so that we don't get all caught up in the logical and legal relevance issues, we could just simply say hearsay is an out-of-court statement offered for the truth. Dean's statement is an admission of a party opponent, which is non-hearsay under California Evidence Code sections 1220. So the reason why we don't have to go into, I personally wouldn't go into this long analysis about logical and legal relevance, is because we know that this statement is an admission by a party opponent. And what do we know about an admission by a party opponent? It's non-hearsay under California law. So it's not actually hearsay. It's not hearsay. And we just need to let the court know quickly that this is not hearsay. If it was hearsay, then we would have to go into analysis of exceptions. But this is not hearsay. So I'm not going to waste my time trying to earn points by going into this long analysis of how calling it hearsay and then looking for hearsay exceptions. Because if you call this admission hearsay in the California bar exam, then you're going down the wrong road. And so what do we never want to do? You never want to go down the wrong road. Okay? So anyway, my stupid computer's not working. Oh, there we go. Here I am. Don't go down the wrong road when you're doing a question. Admissions by a party opponent in a criminal trial is not hearsay. So you just basically state real quick, hearsay is an out-of-court statement offered for its truth. You let the reader know that you know what hearsay is, but you also let the reader know you know what it isn't. And what it isn't is an admission by a party opponent. The criminal defendant making an admission saying that he killed somebody to his wife is not hearsay. It's actually an admission. So it's non-hearsay. Okay, so it's not an exception. It's just not hearsay. Okay, and so I would just put a quick paragraph saying that hearsay is an out-of-court statement offered for its truth, and that Dean's statement is an admission by a party opponent, which is non-hearsay under California Evidence Code 1220. Thus, the statement is admissible as Dean's own admission, and boom, you're done. That's it. It's four-liner. It's a four-liner, and no need to go through exceptions and all this bullshit. Okay? So then we go into the second prong of a question 2, or you could put a B or whatever you want. And now we're going to get into the meat of it, the marital communications privilege. Okay? So marital communications privilege is different from spousal testimonial privilege. And I know some of you might be saying, but duh, but it actually took me quite a long time to sink this through my head. The spousal testimonial privilege is about whether or not we can call her to the stand, and whether or not the testimony itself is admissible, whether or not she could even be called to the stand, right? Testimonial. It's about whether or not we can force this woman to get onto the stand and testify against her husband, right? But the marital communications privilege has to do with statements that were made during the marriage. Like in our fact pattern here, they're in their kitchen during the marriage, in their home, in the kitchen, and whether or not this was a private communication between husband and wife, where the prosecution should be able to allowed to bring in this testimony, even though it was heard by a third person, Ella, who is the neighbor, and whether or not that admission is protected, okay, under California law. So therefore, California also recognizes this marital communications privilege, and this is from the same section of the code, Evidence Code 980, okay, and this applies to one. It applies to confidential communications between spouses. Confidential communications, okay. What does that mean? It means that they believe that they're having this private, confidential, no one else is supposed to know about it, communication between spouses. And why would the court allow such a thing? Is because we have to protect the sanctity of the marriage, that we hold marriage to be more important than, not necessarily of putting away murderers, but that we place a value on the covenant of a marriage, okay? Or at least that's the way I see it. And then the second prong is the privilege is held by both spouses. So it's held not only by the wife, but it's also held by the husband, okay? And then that the communication must be made in confidence, not intended to be overheard. Okay, so the facts tell us here that Ella testified that on the night Vicky was killed, she was standing in an open window in her kitchen, which was about 20 feet from an open window in Dean's kitchen. She also testified that she saw Dean and Whitney, and she heard Dean tell Whitney, "I just killed a gal who stole my biggest account." Okay, Dean and Whitney did not know. They did not know that Ella overheard their conversation. It doesn't say that he yelled, "I just killed the bitch." It says tell, as in I told her. Okay? But they're in their own home. They're 20 feet away in their own, it says here Vicky was killed. She was standing in an it's Ella who testified on the night Vicky was killed that she was standing by an open window in her own kitchen, which was about 20 feet away from an open window in Dean's kitchen. So she testified that she saw Dean and Whitney, and she heard Dean tell Whitney, "I just killed somebody. I killed the girl." Okay? Now, I don't know if this lady's a snooper, and maybe she's always like interested in what's going on between Whitney and Dean. We don't know any of that stuff. But I mean, she's 20 feet away. And yes, there's open windows, but it doesn't sound like necessarily that they're fighting, right? We don't know. All we know is up here in the facts up here is that at Dean's trial, the prosecution called Whitney, Dean's wife, to testify 1 week after the murder. It says 1 week after the murder, Whitney had found out that Dean had been dating another woman. So at the time that they're having this conversation here, she doesn't know that Dean's stepping out on her. She doesn't know that. So there's nothing here to suggest that they're fighting. But the bar examiners put this paragraph first, and they make it seem like she found out he's cheating. But if you miss this part right here, 1 week after the murder, your brain is gonna think, oh, they're fighting, and he's yelling. See, they use the word tell right here. This word tell, Whitney, because they want your brain to miss that letter. That instead of tell, it's yell. Dean yelled, and I just killed. So your brain might think, oh, they're fighting, and that's why she overheard 20 feet away. But they're not. That's not fighting at all. You're making this presumption. You're assuming that because she found out a week after the murder that she found out that he was stepping out on her, that she was angry and that they're fighting right here. But they're not. He just tells her. So we don't know. He could have been like, yo, baby, just between me and you, I killed that bitch. That took my biggest account, right? We don't know. Okay? So when you're taking an exam, we have to be careful not to assume facts that are not there. Okay? The facts don't tell us that they're fighting and arguing in the kitchen. Like, what if he was yelling, I just killed her! I don't know what I did! I just killed her! And then you could make the argument that this was not a private communication. It wasn't private because he's yelling it at his screen. He's screaming. He's freaking out. And his neighbor, a snoopy neighbor, overheard him yelling and said that he made that admission. But the facts don't tell us that. And they also don't tell us that she's a snoopy neighbor. We just know that she's 20 feet away in her own kitchen and she can hear. So our brain can go all kinds of different ways with this, right? Okay, but let's get to so let's apply this, right? So the prongs are, we already know that the communication is confidential. So California recognizes this privilege so long as the communication is it only applies if to confidential communications between spouses. 2, the privilege is held by both spouses. 3, the communication must be made in confidence, not intended to be overheard. So I think it's safe to say, we'll get into that. If the communication is overheard accidentally, it may still be privileged, so long as the spouses reasonably believed it was private. So that's going to be important for our analysis here. So let's just jump right through the analysis, okay? So Dean and Whitney, they were speaking inside their home, okay, and through open windows, and unaware that Ella could hear them, because the facts, I believe, if I remember correctly, tell us open window. She was about 20 feet away. She also testified she saw blah blah blah. The prosecution, Dean and Whitney did. Oh, right here, Dean and Whitney did not know that Ella overheard their conversation. So the facts tell us they didn't know. Okay, so they're thinking that they're having private communication. Okay, so the issue, were they reasonably expecting privacy? And I think yes. Okay, so the courts will apply a reasonableness standard, obviously, because the rule says it does. It says spouses reasonably believed it was private. Okay, so the court's going to apply this reasonably expecting privacy. Okay. So the court applies the reasonableness standard. So here, although the windows were open, the conversation occurred in their home, a setting where spouses generally expect privacy. A reasonable person likely would not expect a neighbor 20 feet away to overhear through another window. Absolutely. Like if I was having a conversation with my wife in our kitchen, and I wouldn't expect that the neighbor, I'm not going to tell you what her name is, but I do have a neighbor and her husband, and if they could hear, if I was having that conversation, I would have reasonable expectation of privacy in my own home that my neighbor could not hear us. Okay, so this means that the communication was privileged, in my opinion. So thus the communication was confidential and therefore privileged. Okay, so the marital communications privilege applies even in criminal cases and even where the testimonial privilege does not. Okay, let me read that again. The marital communications privilege applies even in criminal cases and even where the testimonial privilege does not. Okay? All right, so because the privilege belongs to both Dean and Whitney, neither can be compelled to allow disclosure. Okay? So conclusion, I think, is that the court improperly admitted Ella's testimony because even though she overheard the conversation, it was protected by the marital communication privilege, and the privilege was not waived. Okay? So that's her. So now we're going to go to prong 3, whether Fred's testimony about Hit and Gus, the testimony about Hit and Gus was properly admitted. Okay? So we know that Fred testified that he overheard Gus ask Hit whether he had taken care of the assignment concerning Vicky, followed by Hit drawing his, he put his finger across his throat. Okay? So this also raises issues of hearsay, non-hearsay, circumstantial evidence, because this is obviously circumstantial, and the statements against penal interests. Okay, so again, we start with hearsay. Now Gus's question, and Hit's gesture are obviously out of court statements. Okay, so I think the defense would presumably offer them to show someone else killed Vicky, suggesting that Dean was not the killer. Okay, so a rule here for statements of third parties offered to prove someone else committed the crime. Okay, so that's what we're going to talk about. So the rule here for that is a statement offered to prove, that another person is guilty normally must fall within a hearsay exception. Okay, so California does recognize declarations against penal interests. That would be Evidence Code Section 1230, requiring 1, that the declarant is unavailable. Okay, the declarant is unavailable. 2, the statement was against the declarant's penal interest when made. Okay, and then 3, the statement is trustworthy. I don't know if the statements are going to be trustworthy, considering that this is Hit, who's a well-known gangster, and this guy Gus, who we don't really know much about Gus. Fred testified that he heard Gus ask Hit if he had taken care of the assignment concerning Vicky, and that Hit then drew index finger across his throat. So these are shady guys. I don't know if they're trustworthy, but here let's just apply it because we're going on almost an hour here, and I like to keep the show under an hour because I know that we have short attention spans. Okay, so application. So Gus's question, did you take care of the assignment, is not directly against penal interest. It's ambiguous and is framed as a question, not as an admission. Okay, so that's important. It's framed. It's how it's framed. It's a question. So he's not saying I killed her or that imagine if he said instead, hey, I asked you to kill that woman. Did you do it? That might be an admission because he's saying his statement, hey, I asked you to kill that woman. That's an admission. Did you do it? That's different than him saying, he asked him, testified that he heard Gus ask Hit if he had taken care of an assignment concerning Vicky, right? So he's asking it in the form of a question, not as an admission. Okay, so that's important to make that distinction. So Hit's gesture, finger across the throat, is a nonverbal assertion and would be hearsay if offered for its implied assertion that yes, I killed her. Okay. However, the prosecution is not offering it. It's the defense who's offering it to show someone else committed the murder. Right? It's not the prosecution. So a statement against penal interest must be a direct confession or inculpatory declaration. Okay. A gesture may qualify, but courts in California are pretty strict about that type of stuff. So it could qualify, but I don't know. However, the biggest issue here is that people could probably hear that. I need to turn that off. Okay. So, however, so the biggest issue here is Hit and Gus were not shown to be unavailable. Okay. There's nothing in the facts to say that they're not available, that they skipped town, or that Hit killed Gus afterwards and then killed himself. There's nothing like that. So without unavailability, Section 1230 cannot apply. So there's that. So remember, one of the prongs is under 1230. So recognizing declarations against penal interest, in order to bring that in that testimony, the declarant would have to be unavailable. Okay? And prong two, remember, is the statement was against the declarant's penal interest. Okay? And that the third one, the statement is trustworthy. Okay? But here, our biggest issue is that the declarant these guys are not unavailable. There's nothing to suggest in the fact pattern that they can't be called to the stand. Okay? So that means that 1230 will not apply. Okay? So non-hearsay purpose, Fred's testimony, for a non-hearsay purpose, so this would be a new prong now, as in non-hearsay purpose. So question, for a non-hearsay purpose, can we bring in the testimony for a non-hearsay purpose? That's what we're getting at now. So the first one was hearsay, that was A, and now B, we're talking about whether or not this testimony, whether or not a statement offered to prove that someone else is guilty, can it be brought in under non-hearsay for a non-hearsay purpose? So Fred's testimony might be offered to show, for example, that effect on the listener. Fred became suspicious, right? So not relevant. It's not relevant, right? It's or circumstantial evidence that others had motive or opportunity. But if the statement is being used to show the truth of the matter that killed Vicky, then it's hearsay, okay? And what's the relevance here? So we have, we talk about relevance. Okay, this is the first time we're bringing up relevance. Obviously, if evidence suggesting that a third party committed the crime is relevant, if only if it directly connects the third party to the crime, right? So an ambiguous gangster talk in a restaurant or wherever they are. I think they're in a cafe, next to a table. Testified after Vicky was killed. He had lunch at a coffee shop. So there's this two guys at a coffee shop. It's very ambiguous, this conversation between this gangster and Gus. So, in other words, ambiguous gangster talk is too speculative and is often excluded under Evidence Code 352 for undue prejudice and confusion. You have that list of legal relevance where unduly prejudicial or confuses the jury, right? We don't have to go into a whole crazy analysis on that. You just kind of just hit like how I just put it, that this talk between these two guys is too, in a coffee shop is too speculative, and it would be excluded under Evidence Code 352 for undue prejudice and confusion. I personally wouldn't put a whole subsection prejudice and then confusion. Like, it's just too much. It would take up too much time. So you just let them know, hey, you understand Evidence Code 352, and that it would be excluded for undue prejudice and confusion, and I think you'll get your points. And then you just give a conclusion. Fred's testimony should be excluded because it's hearsay without any exceptions, and there's no unavailability for declarations against penal interest, and it's not clearly a statement against a penal interest, right? Because it's a form of a question, and it's speculative, and it's properly excluded under 352. Thus, the court improperly admitted Fred's testimony, and that just ended there. Okay. So, final conclusion then is that allowing. So, if we go over this whole thing about testimony, bringing in A, B, and C, we can conclude that allowing the prosecution to call Whitney, that was proper. But Whitney's compelled testimony, improper, because it was because of testimonial privilege. But Ella's testimony is also improper because of the marital communications privilege. Okay? And then Fred's testimony is also improper because it's hearsay with no exception under 352. It's prejudicial. Okay? So that is the breakdown of question 2012, July 2012, question 3, evidence question. Okay, it's a long one. It's a racehorse. You got to get through it. But you'll notice that there's only so many issues, like main issues. It's the testimonial privilege for question 1. That's all it is. It's a pretty long analysis, but it's just that's all we're talking about is testimonial privilege. Okay, whether or not the prosecution could call her to the stand. And then question 2 is just the admissibility of the witnesses that were on the stand and made statements. Okay, the the first one for Whitney is just about the communications privilege during the marriage, making the statement that he had killed the girl to his wife and in their own home, believing that the communication was confidential between just the two of them, and whether or not that was reasonable or not. Okay, and then with Ella, it's whether or not that communication, whether or not it was reasonable for them to believe that testimony was okay. And then Fred, the conversation in the coffee shop is just too speculative. So a good defense attorney would, as you get over time, is going to be able to where you're reading this question, you're like, oh yeah, this guy's guilty. Like, how do you even get out of that? How do you got the wife who's on the stand testified about the mug. You got Ella who testified that she overheard the statement about him, killing his wife, and then you got the other guy, Fred, who says that someone else killed Vicky. How do you get through all that? Well, if you know these rules, you'll be able to just logically go through them, and you can come through a conclusion. Anyhow, it's Saturday. This is the day that we got to hit hard. Hit as many MBE questions as you can. I know that there's always family obligations. I got a birthday party I have to go to in a little bit, and I'm only going to go for 2 hours, and then I'm coming back. I shouldn't even be going, to be honest with you. But, what are you going to do? Life gets in the way. So instead of throwing the whole day away, you could take little booklets like this that you make, okay? And you could do the same thing with the MBE. The ones that you get wrong, the rationales that they give you for what the correct answers are and what the wrong ones are, you could put rule statements or whatever you think is going to help you remember and put it on here, and then throughout the day, and then you should have a big pile of these as time goes by, a big pile of these. Just keep going through them, keep writing them out, just keep making little booklets, and just do whatever you can. Me, I decided to do this podcast thing because it's going to help me remember this stuff as well. And it builds community and all that kind of stuff. So, keeping that in mind, join me, subscribe to this channel, listen. If you're just sleeping at night, or if you working on this particular question, then just give it to me. Ask me. You can ask me questions about it. Actually, if you have a question that maybe you're working on one of these essays on the State Bar's website, but like, hey, would you mind doing this question? Let me know in the comment section, and I'll be happy to put together an episode dealing exactly with the question that you want to know. And I also plan on doing short little videos like I did yesterday that are just about one little topic. Like, for example, I'm going to do one later today that goes through spousal testimonial privilege. It'll only be about the spousal testimonial privilege, and then maybe even I'll do it the difference between spousal testimonial privilege and the communications privilege, right? Because the communications privilege, obviously, as we know, is a little different and it applies different. The marital communications privilege had more to do in this particular situation with Ella's testimony, that she's saying, I heard him say this to his wife, right? And so if you don't know, if we don't have this marital communications privilege and we don't understand it, we may use that marital communications privilege as we're in place of the testimonial privilege, thinking it's the same thing. It's not. The testimonial privilege is about whether or not the wife can be compelled to testify about what he said against her own husband, whereas the marital communications privilege is about whether or not this third person can testify as to what was said by the spouse to the other spouse. You see what I'm saying? So I'm gonna do a short video on that later today. So check that out later, and I'll be and I would love to. If you want to see that, drop a thumbs up in the comment section. If you're looking forward to seeing that, and you want to make sure that I do it. Also, if you made it this far in the video, make sure you put a thumbs down so that I know California bar exam sucks and they're a bunch of bullshit, and we got to get through it together. We're gonna get through it, guys. All right, so thank you for joining me for the show. I hope you enjoyed it. Let me know what you thought of the show, comment sections, share, like, and subscribe. Give it to one of your law school buddies or or somebody you know who's probably studying for the bar exam in 2026, February 2026, so that they know that the show is here and it's here for them. It's free. You guys can watch it. If you guys think that I did something wrong or I said something that wasn't true, then please let me know in the comment section. And then I'm either going to say, you're right. Or I might say, go fuck yourself. I don't know. We'll find out. All right, guys. All right, man. I hope that you get good studies in today. Thank you for watching.